Welcome back to Court TV Live. I'm Michael Ayala. More than 30 years after the movie Top Gun was released, its sequel is breaking box office records. But now, the widow and son of the man who wrote the 1983 article that inspired the original Top Gun are suing Paramount Pictures. All right, joining me now as a special guest for this segment is copyright and entertainment attorney Marc Ostrow. Marc, thank you so much for joining me. Truly appreciate it.
It's a pleasure to be here, Michael.
All right, let's start off by how this process works. Some of our viewers may not understand. A guy writes an article, 1983, someone reads it, decides, hey, this might make a good movie. Tell me about that situation and how he's compensated and how the rights sort of flow.
Well, this is basically what happens is the film company would take an option agreement and essentially buy the movie rights. And that is what the plaintiffs have alleged in this case, that shortly after the original article appeared, that they entered into an assignment agreement, essentially, of the movie rights, and that's when they made the original Top Gun movie. So an acquisition fee for those rights would have been paid, and that's basically the process.
All right, so what type of money are we talking about here, just generally, if you know?
It can be anywhere in the low six figures to maybe, on the high end, who knows back then, maybe low seven figures. But, buying the rights to adapt, very often, isn't the kind of money that's spent for the blockbuster film itself. Because, we're not talking about, the actual screenplay or whatever. It's just the right to adapt this article.
All right. So a significant amount of money, but when you talk about a film that may make hundreds of millions of dollars, not a lot at the end of the day. Now,
right, exactly.
Right, exactly. All right. So copyright law, though, kind of takes that into account. It accounts for that by giving the copyright owner, the original author, the right to grab it back. Tell me about that and how that plays into this case.
Okay. Well, this is a fairly technical area of copyright law. We're talking about copyright terminations. So as you said, Michael, under Section 203 of the Copyright Act, for those who like looking this stuff up, 35 years after what they call the grant in the statute or an assignment, here the option agreement that was entered into in 1983, the creator, the author, or if the author is deceased, the heirs listed in the statute, in this case the widow and son, can serve a notice on that grant, grantor, saying we're terminating the rights, and you have within a 5-year window to terminate that grant, starting 35 years after the original assignment. And what's key here is you cannot have an effective date for the termination to be less than 2 years from the date of the service of the termination notice. So that comes into play with this lawsuit.
All right. So now, I guess the big question everybody wants to know, and putting it in its most simplest terms, who's the bad guy here? I mean, you can see one side where folks say, oh, this might be just a money grab. They see the success of this sequel. They want to grab some money. But you also see the other side where Paramount might be saying, you know what, we were going to do this regardless of these rights sitting out there, whether they had expired or not.
Well, from my vantage point, and other people in some of the articles that have come out have stressed this is a statutory right under the Copyright Act that all creators or their heirs have. And this is a fairly common process. So, I don't want to say that anybody is the bad guy, but clearly Paramount dropped the ball in not responding to this exercise of statutory rights. So they, at least according to the allegations of the complaint, the notice of termination was ignored until the plaintiff sent that cease and desist letter that you mentioned in the intro back in May. So they should have, the statute has an interesting provision. Once the notice has been served, nobody can make, the terminating parties can't make a deal with any other party except the party they're terminating prior to the effective date of the termination. Again, that's a little complex, but basically the heirs can't make a deal with anybody else except Paramount here until the effective date. So Paramount had some bargaining power to re-sign the rights, which is a fairly common occurrence, for 2 years prior to anybody else being able to negotiate for those rights.
So it sounds to me like when you say they dropped the ball, they really did drop the ball. They could have avoided all this and probably got a pretty decent deal to remake this sequel. Finally, your thoughts on the viability of this lawsuit. Do you think they have a chance of winning it?
I think they do. I've read through the complaint. It's a good complaint, and they have attached, to show copyright infringement, they have to show that this work is substantially similar or derivative of the original 1983 story. They attached 19 pages, side-by-side similarities between the original article and the 2022 Maverick movie. Now, granted, this is pleading, and some of these similarities, may not be real, or some are better than others. But given that the original movie was based on that article and many of the same characters are involved, I think they'd be pretty hard pressed to say that the new movie is not in some way based enough on the original story to be infringing of that story.
Yeah, I'd have to agree. When you talk about derivative, I think that's one of the clear issues here as far as I'm concerned. And I did read that complaint, and I agree. I think many of the things do match up. All right. Well, thank you so much to copyrighted entertainment attorney Marc Ostrow for joining me tonight. Truly appreciate it. Thanks for all your insights. Really cleared up a few things for us.
It's been a pleasure.
All right. You have a great evening now.